1. Greetings, dear colleagues, the candidate and the public. Today, on January 20th, 2025, the advisory group of experts met to interview the candidate for the position of Judge of the Constitutional Court of Ukraine, Olena Fitsai. In particular, all AG members are in attendance. Mr. Eller Salar, Mr. Yaroslav Romaniuk, Mr. Vasil Shakun, Madam Hanna Suhotska, AG Secretary, Maureen O'Connor, and me, AG Chair, Oksana Vasilchenko. AG members, deputy members are also present at the interview. Mr. Marek Zubik, Mr. Volodymyr Kuzmenko, Mr. Vitaly Makhinchuk. I'd like to note that we're working in a shelter, so in the event of the air raid alert, interviews will be continued without interruption. I also remind you that the interview is recorded and broadcast live on the AG web resources and on the Constitutional Court of Ukraine website. I remind AG members and the candidate that using sensitive data and restricted information must be limited while on the live broadcast. Should there be need to discuss such questions, the AG will pause the broadcast for that period. We are ready to start, so I give the floor to AG Secretary, Madam Maureen O'Connor, to briefly introduce the candidate and reiterate the rules of procedure for the interview. Madam Maureen, the floor is yours. Thank you, Madam Chair.
I greet you, dear colleagues, as well as the public who is viewing what we are doing here this afternoon. As was just mentioned by the AG Chair, the advisory group of experts will now interview the candidate Olena Fitsai. Thereby, I hereby recall that the interview is a mandatory milestone in assessing candidates within the assessment of their compliance with the criteria of high moral qualities. The time allotted for one interview is approximately 1 hour, and the time limit for answering questions is no more than 3 minutes. As always, we ask each candidate to be concise and to provide answers that are clear, that are unambiguous, and that reach the point. At the end of the interview, the candidate may make a brief final remark, no more than 5 minutes. I'd also like to point out that in the course of processing materials about the candidate Fitsai, the AGE sent her questions to provide written explanations. So the candidate had the opportunity to both prepare for the interview as well as provide answers. So now here's the candidate for the position of Judge of the Constitutional Court of Ukraine, Olena Fitsai, whom the Selection Commission under the President of Ukraine has admitted to the competitive selection. In July of 2024, Ms. Fitsai was appointed as judge of the Lubin District Court in Poltava region. She has also over 20 years of experience working in various state institutions, including the Department of Penal Enforcement, the State Judicial Administration, and the Slavuch Interdistrict Prosecutor's Office. Ms. Fitsai, if I have missed anything in your introduction or something you would like to supplement with, please do it now for up to 3 minutes.
Nothing to add. Thank you. Everything that Madam Maureen has mentioned is correct.
Okay, we'll begin the questioning. Mr. Romaniuk.
Greetings, Olena Leonidovna. I would like to start with the questions regarding apartment privatization. In September 2012, your husband, as far as we know, an employee of prosecutor's office, received an order for an apartment with a total area of 68.8 square meters in Kyiv. The order was issued for a family of two, your husband and his mother. As far as we know, since that moment and until 2021, your husband's mother lived in Tachiv, Zakarpattia region, which is approximately 1,000 kilometers from Kyiv, which makes it obvious that she was not part of the immediate family, and she was not in the need for an apartment in Kyiv, and she was not living there. Why was the order issued for your husband's mother and not you? When my husband received the order, we had just gotten married. That is why the decision to not include me in the order was my husband's decision. We did not have any prenup, and we decided to do it this way so that I do not have any claims for this property in case of divorce. This was our agreement. I was not included in the order, and I did not take part in the privatization. As you explained in the written communication to AG, approximately from mid-November 2012, you lived in this apartment. Yes, we were already married at the time. I was also expecting. Why did you not register yourself in the apartment? Again, this was the decision made. We were not sure how our family life would develop, so to exclude the chance for any property claims, we decided to do it this way. Understood, thank you. The next case that drew attention of the AG was that on December 1st, 2012, your husband received the right to represent her interest in various government authorities regarding privatization, and in January 2013, he received the same document from his mother's sister, with the right to represent her interest in various government authorities regarding privatization. Again, you were living together with your husband. Why did you not participate in privatization? Why did your husband did not participate in privatization? Instead, those were people who did not live in this apartment and who lived 1,000 kilometers from the capital. This was the decision of my husband's family and my husband. Did you not have a vote in your family? I agreed to do this. As I have already said, we did not have any prenup agreement, so to avoid any property claims in the future in case of divorce, we decided that the privatization will be conducted this way. At the time, did you already execute your right for privatization? No, I have never done this. Okay, let's follow this case. So this apartment is privatized by your husband's mother and her sister. And in September 2013, this apartment is sold for 600,000 hryvnias. Again, it is your husband who handles the sales of the apartment. After this, as you explained this in the written communication, starting from 2014, you and your husband register for the improvement of accommodation. Yes, this was the first case of me registering for this. During previous communications with AG, you confirmed that starting from 2014, you have been on the housing register at Svetoshin District State Administration. Yes, that's right. This was the first time when I was registered. You should understand the goal of constitutional reform. The goal is to enhance the level of trust from public to the Constitutional Court. In your case, from the standpoint of view of an external observer, will this contribute to building the trust from society to the Constitutional Court? How come your husband receives the apartment, privatizes it in the name of his mother and aunt, then sells it, and then registers himself in the housing register? I can say that this is not relevant for the case of my integrity because I did not participate in organizing the documentation or in the sell and purchase agreement signing. This is your opinion, right? I believe that this doesn't concern me personally. And you believe that the public trust towards your personality as a potential judge will not be affected. I understand that on the basics of ethics, the judge should be well aware of the integrity of his family and the sources of funds across his or her relatives. I believe that I do demonstrate the level of integrity personally and in my work. I personally did not want to receive multiple apartments from the country, and I didn't do anything to prove this wrong. Thank you. Moving on. So we talked about 2012, 2013, 2014. In your annual declarations for 2016 and 2017, you indicate that from January 2016, you and your family members had the right to use an apartment in Kyiv with a total area of 71.5 square meters. This apartment belonged to your husband's mother, is that right? Yes. Why did you not specify the value of this apartment in your declarations? At the moment, I did not have the documentation, the contract of Sale of Purchase Act for this apartment, so I did not have this information. Then, when I was preparing to become a judge, I studied this question more thoroughly to avoid any complications and to clarify this information and state it correctly. Again, back then, your husband's mother continued to live in Tyachiv in local press editor's office. Where could she get the funds to purchase an apartment with the total area of 71.5 meters in Kyiv? Partially, these funds were received after she sold the privatized apartment. What was the goal of purchasing this apartment? It is obvious that she didn't need an apartment in Kyiv. Not then, not in 2021. She was still in Tyachiv, the Carpathia region. Yes, but she had the opportunity to purchase it, to invest money in the property, in the real estate, so she decided to use it. Again, all matters were handled by your husband. Yes, because he lived in Kyiv. It was more convenient for him. Also, he's a lawyer. And for his mother, it was quite difficult due to health issues as well. So, having the right to represent her interests, he purchased this apartment and you lived there. You lived there until August 28th, 2018, when the next sale and purchase agreement was signed and this apartment was sold. However, even after selling this apartment, you continued living there for approximately a year. How did this happen? You lived there, then you live there for another year after selling this apartment. So what was the real purpose of signing this sale and purchase agreement? We decided to sell this apartment and to purchase another apartment. This is the need that we had. However, since we did not have our own apartment, the person who purchased the apartment was planning to rent it. That is why we decided, and it was also convenient for the person who purchased it, that for another year we will be staying in this apartment. On what rights? As renters. So you paid rent for this apartment. Yes, we did specify this in the sell and purchase agreement. We did specify when we will move out. So you were paying rent. And did you specify this in the declaration? When selling the apartment, we calculated a certain sum of money, so we reduced the sum of purchase of the apartment to the sum of the rent. So you included rent payments in the sell and purchase sum. Yes. Understood.
If the candidate would wait until Mr. Rumelnik is finished with his question before she answers, that would greatly help the interpretation for me. So let's slow it down, please. Mm-hmm.
According to the sell and purchase agreement, this apartment was sold, as it is specified in the agreement, for 1,795,000 hryvnias. And you reflected this in your declarations, that this apartment was alienated. At the same time, for some reason, you also specified a different sum in your declaration, which was 1,869,000 hryvnias. The difference is not that significant, and yet, what was the reason for this mistake? As we figured it out later, it was just a clerical mistake. I cannot explain it. It was just calculation mistake during filling out the declaration. Am I understanding this correctly? That this demonstrates the lack of your diligence to fill it out in the declaration. I did not aim to hide anything in the declaration. Thank you. I will now give the floor to my colleague, Madam O'Connor.
I'm going to draw your attention to some purchases that involve your husband. On November 12, 2020, your husband acquired ownership of a new Toyota Camry, obviously a 2020 model. What was the cost of this car?
The cost of this car was, according to the sell and purchase agreement, just give me a second to take the documents. It was approximately 800,000 hryvnias.
But this was a new car. We confirm that?
Yes, it was a new car purchased at the official dealership.
That your husband managed to acquire a car for such a price, because according to the listing for sale at the time, a 2020 model posted on a website for sale from October to December of 2020, the lowest price for such a car was 1,045,515 hryvnia, which was the price for a used car, not a new car. So the price of 800,000 is significantly less than what would be ordinary or expected.
I can only explain that my husband bought in this car in the basic configuration, and cars with this basic configuration cost that amount. In 2020, we have the official agreement, and I have provided it to the AGE upon its request. We have the official agreement, and that was the price determined by the only official dealer in Ukraine. It was the simplest basic configuration. The interior was not made of leather but of clothes, so it was the price for this class of the vehicle in this particular configuration, and that was the price of such vehicle in 2020 when we bought it. So everything was official. We have official agreement. That was the price established by the dealer for back then.
Okay. I'm going to draw your attention to the declarations. In your annual declaration for 2018 to 2023, you stated that you, since September of 2012, your husband since January of 2013, and your daughter since January of 2013 have had another right of use, a residence registration for a dormitory. What is this dormitory, and on what grounds was it your place of residence that you would register it?
So, after graduation from Yaroslav Mudry National Academy, my husband started working in Svetoshin District Prosecutor's Office since July of 2006. And since he deregistered as a student from the dormitory in Kharkiv, and in order to ensure the exercise of election rights and other social rights, he was registered in this dormitory. This registration took place based on the letter of the management of the prosecutor's office. Back then, it was believed in the prosecutor's office that employees had to have this place of registration in Kiev, among other things, for military registration as well. As far as I know, that is internal affairs dormitory. And no agreement of use was concluded. It was just registration of the place of residence since he worked in the prosecutor's office in Kiev. So that's why it was necessary to be registered in Kiev. Further on, as a wife, according to the legislation, I was registered there, and our children were registered at the place of residence of registration of our husband. So, when declaration was introduced and when the new law on corruption prevention was adopted, there were no explanations from the NACP regarding the fact what should be registered, in particular with respect to the place of registration. And taking into account provisions of the law on corruption prevention and of the civil legislation, we did not envision this duty to declare the place of registration. So that is why I did not have this information in my declarations for 2016-2017. When I took part in the selection for the position of the judge in 2018, and when the special check. Olena, we have simultaneous interpretation. Can you be a bit slowed down? Yes, sorry. So, when I took part in the selection for the position of the judge, the NACP conducted a special check of my declaration. And I was told that it was a mistake, that I did not declare the place of registration. And subsequently, I corrected this mistake and I started declaring it in my declarations. So we do not even have a specific room there. It's just the address. That's it.
Neither you nor your husband nor any member of your family used a room at this dormitory. Is that correct?
Yes, correct. No room was even allocated. That just addresses the place of registration. It was the practice back then that existed. Employees of the prosecutor's office were registered in such a way, and accordingly, I and our daughter, as family members, were also registered at this address.
The right to use this dormitory because by way of that registration, if you needed it.
No, we would not. No room was even allocated. There was no order for some specific room there.
Right.
So I understand that it looks illogical and unclear, but back then it was the practice. They registered employees of the prosecutor's office in such a way.
Okay, so you're saying, though, you had I mean, it's a little contradictory. You were registered, you had a right of use of this dormitory, and I'm just wondering if you individually had a right to use it. If something happened and you needed a place to stay, could you pursue a room at the, or, accommodations at this dormitory?
As far as I know, no.
All right. In the 2017 declaration, you stated that your husband received a gift in the form of money in the amount of 100,000 hryvnia from his mother during the relevant reporting period. Why did your husband not submit a corresponding notification to the National Agency for Corruption Prevention about this acquisition and this change in status due to receiving this gift?
Because it was not a one-time gift. These were some specific amounts. The total amount for the year was 100,000 hryvnias, but one-time amount was not subject to declaring.
Interpretation, or does the law specifically say that incremental gifts in 1 year period of time within the reporting period need not be declared at the time of the reporting period? Is that what the law says?
The law says the amount that is subject to declaring if this amount is received during one-time receipt. And since this amount of the gift was not given once, it happened within a year. And as of the end of the reporting period, this was the amount, and it was declared for the entire reporting period.
You're saying that your husband did report it or not? The entire amount?
For the reporting period in the declaration for the respective period. So he declared this amount for the reporting period. I don't remember how specifically it happened and which amounts were gifted by his mother, but as of the end of the year, it was the amount that was subject to declaring according to the law on the corruption prevention, and this amount was declared.
Declared by you or by your husband?
My husband. And accordingly, once I declare, I also declare his income in section income of family members.
Interview with the High Council of Justice, you mentioned that in 2017, the $100,000 hryvnia was a gift from your husband's mother to him for a holiday. What did you mean by that? What holiday did the mother gift him the money for?
His birthday of the child. I cannot recall specifically which holiday it was.
Okay.
And for birthday as well. And for granddaughter's birthday as well. That is on the birthday of our daughter.
Okay. All right. I heard before when you were being asked questions by Mr. Yaroslav, that you say that a judge must be aware of family wealth. That's the obligation, special obligation for a judge, applying for a position, and obviously it's for transparency and public trust. Okay? So, in your husband's mother's 2018 declaration, it's stated that she made a gift transaction of 2 million hryvnia in the relevant reporting period. To whom and for what purpose did your husband's mother gift the 2 million hryvnia in this reporting period?
As far as I know, these were funds gifted to her daughter.
Gift agreement was signed?
No. A written deed of gift was not concluded, as far as I know.
According to the information from NABU on October 17th, 2023, the father of your husband was gifted 1/2 interest in land, a plot of land with a total area of 0.87 hectares, and half interest in the property complex with a total area of 1,758.8 square meters. Who gifted that property and why?
I do not know about this. I have specified that in response to the AGE's request, I do not know about the details because my husband's family does not discuss these issues with me. I know something in general about some property that they have under the right of ownership, but I do not know any details about acquisition of that.
Тому я, на жаль, не можу.
So unfortunately, I cannot answer regarding this anything, and I have provided that in my explanations. So I have provided all the information that I could provide with integrity. With respect to other questions, I have not provided that because I do not know it.
Make an effort to ask your husband's father about the transfer of this property?
Ми
We talked back when we received the first request. He and his wife were abroad. They were visiting their daughter in Prague, in the Czech Republic. So, to clarify details, to find documents, it was difficult. In order to clarify everything in detail and to provide supporting documents, it was impossible.
Just 1 minute, please. Did you ask these questions? No, you were supposed to. Yeah, all about the property, yes.
Тепер дозвольте мені.
Now let me continue with asking questions. We discussed 2016-2017. Let's move on. According to information specified in your declaration for 2020, you and your family lived since January the 1st of 2020 in an apartment with a total area of 91.7 square meters in Kyiv, in the residential complex French Quarter. Is that correct? Yes. As you have informed, the price of this apartment is 3,758,315 hryvnias. Who is the owner of this apartment? This apartment is owned by the sister of my husband. This time not by my mother, but by sister. Yes, this apartment is owned by his sister. Where is sister? Sister lives in Prague. In the Czech Republic. Yes. Why did his sister need an apartment in Kyiv? Because back then, as of the moment of the purchase, she had the opportunity to buy it, and she also considered the opportunity to move back to Ukraine, as far as I know, so she decided to invest into real estate in Ukraine, in Kyiv. We have not found any supporting documents to confirm that she transferred funds to Ukraine. So what was the way how she did that? Maybe the customs declaration on import of cash or bank transfer? How did these funds come to appear in Ukraine? She comes to Ukraine quite often. She comes to Ukraine at least 3 times per year, and she imported 10,000 every time. Yes, partially the mother gifted 2 million, and probably these funds were kept by my husband's parents in Ukraine. You know, I'm not that close to my husband's sister to know these details from her. Quite a strange role of you in your family. You have no relation to any property issues. Well, some people conclude their marital agreement. But you use the property owned. Yes, I do. As a wife of my husband, I do use it. But you have no relation to its acquisition. No, in no way. The only thing is I have provided the power of attorney for conclusion of agreements for water and supply and heating. That's the only thing I had relation to, because we lived there, we used utility services, so it was necessary to do that because the apartment was new. Okay, clear. Olena. The apartment was bought by the sister. Did she come here to Kiev on her own to conclude the sale and purchase agreement? Frankly speaking, I cannot answer this question. Did she come here to choose the apartment, to check it out? I cannot answer this question. According to our information, your husband was doing that. For sister, but your husband, because he is here and it's convenient for him, but you live in this apartment together with your husband. Yes, because it was before the war. The sister bought it before the full-scale invasion. She did not have her family there, and she considered the opportunity to move back to Ukraine because her profession allows her to do that. She's a doctor. Her profession allows her to work in Ukraine and abroad because she got her medical education abroad. And she had the opportunity to do that, so she decided to invest into real estate, just like many Ukrainians invest abroad. In your declaration, you specified that you live in this apartment since January the 1st of 2020. At the same time, the right of ownership was obtained on January 27. So, when did you start living in this apartment? It was not that we started living there on January the 1st completely. Back then, we used to live in this apartment at Kombinatna Street that was owned by the mother of the husband, and we continued living there based on the rent right. We started moving into this apartment, not since the January the 1st that we started living there completely all the time. So we can assume that you lived there after you legally obtained the right of ownership, after your husband, not my husband, but the sister of my husband. My husband did not obtain the right of ownership. The owner is my husband's sister. Okay, as soon as your husband's sister obtained the right of ownership, only then you started living there. Yes, later, after that. It was later than that. According to information at the website of the construction company, the building in which this apartment is located in the French Quarter complex was commissioned only in the third quarter of 2019. Who conducted repair works in the apartment, and how was it possible to conduct all the repair works and to move into it during such a short period of time? We did not move there completely. We declared that we used that apartment, but we did not move there because, yes, the repair works were ongoing. Who was doing the repair works? His sister? Workers were doing that, but I do not know the details. That's a property-related issues, and you have no connection to that. I forgot about that. Sorry. When you were applying for the competition, and for the first instance court, and especially to the Constitution Court, didn't you think that, of course, during the stage of integrity check, there would be questions about the source of origin of funds, there would be questions about supporting documents to confirm these sources of origin of funds? Didn't you think that maybe you needed to find documents that would confirm that his sister is in the Czech Republic and that she could earn this particular amount, that she could bring this amount into Ukraine legally, and that she could use this money to buy the apartment in Kiev? Yes, income of my husband's sister allowed her to buy this apartment. And do you have supporting documents? Right now, I do not have these supporting documents. Haven't you thought about getting these supporting documents from your husband's sister? Now, when I started participating in this competition, it was difficult because she gave birth to a child in October, so it was difficult for her in Prague because before that she worked in the Slovak Republic before moving to Prague, She studied in the Slovak Republic, so in order to get all of those documents for her, she needed time, and it was difficult because she had a newborn child. So unfortunately, I couldn't provide the AGE with supporting documents to confirm her income. But she works officially, and her official salary allows her to buy this apartment. I'm convinced about that. As far as I understand, you decided sometime in August to apply for this competition. You were collecting documents. You applied in August, September of last year, and before that, probably she had the opportunity to get those documents. Did you ask her to do that?
I did, but I'm sure about my integrity. That is why I applied for this competition. I'm not sure if I can put some pressure on my husband's relatives. She's not obliged to provide this documentation for me. If it was about my parents, I would provide this. We did already discuss this. The goal of the constitution reform is to increase the level of trust from society to this organ. In your opinion, the fact that your husband's sister from the Carpathia region works and lives in Czech Republic, buys apartments in Kiev, then your husband hires a construction team to make the repairs, and then you live in this apartment, and you are not able to provide any documentation to prove that these are legal sources of income that were legally brought to Ukraine and were used to purchase this apartment. In your opinion, the appointment to the position of a judge will increase the level of trust to this organ. I can only say that I'm convinced in my integrity, and I provided all documentation that I could have provided. I understand that this is only my word about my sister's income. Unfortunately, I cannot confirm my words as of now. I could not obtain those documents to prove my words. So there is just my word. As a candidate who is sure about her integrity, could you at least scan these documents in Czech Republic? The digital means allow you to do this now. There is no confirmation. As of today, I do not have any confirmation. Okay, thank you. Dear colleagues, any other questions to the candidate?
Just some follow-up here. Is it accurate that both you and your husband, who works for the Office of the Prosecutor General, live in this apartment without paying rent?
Ні, ми сплачували оренду.
We did pay rent. We did not live without paying rent.
Owned by your sister-in-law, your husband's sister. You pay rent to her for living in this apartment?
Ні, ні.
No, in this one, no. No, we did not pay rent. We only paid utility bills.
Okay. That's a very generous situation for you to live rent-free when clearly both you and your husband have sufficient income to pay rent. Is this declared, this gift that you receive each year from your sister-in-law? That the rent is that your housing is rent-free? Does that translate to a dollar amount that you can describe as a gift?
No, we cannot consider this as a gift. This was just an oral agreement to use this property. We only paid utility bills. I do not think that this is gift. I do not think that you can say that this is gift according to the anti-corruption legislation.
What do you think the average Ukrainian would call it? Because we are obviously involved in the reform of the judiciary. The transparency, as I think I mentioned earlier, utmost import. And we are sharing all this information so that in real time the public can hear us question the candidates. And I'm wondering, what would the average Ukrainian man or woman listening to this interview think about the benefits that you're receiving, especially the rent-free in a multi-million hryvnia apartment?
Я можу
I can only say that this is a regular practice when relatives stay at other relatives' apartment, only paying the utility bills and not paying rent. So this was a family-based agreement. I can say that this is a normal practice when relatives do not pay rent to other relatives and only pay utility bills.
Not maybe common. That's fine to listen to that and to hear that that's true. My concern is how do you characterize this? It would be characterized as a gift. It's something that you're getting of value, and not compensating the donor for. That's the definition of a gift. Okay, you don't think it's a gift. I think it's a gift. Let's move on. I want to ask about your current occupation. What is it that you do?
так. Зараз є
Right now, I'm the judge at the Globin District Court. Until December the 10th, I was not working as the judge because I did not take the oath. I took the oath on December 11th, 2024. And starting from this day, I work as a judge. I'm already considering 80 cases as a judge.
So you've been a judge for a little over a month. Is that a fair statement?
так.
Yes.
Want to go from your current position, which is a judge on the district court, a very honorable position, but you want to leap to the highest court of the country. Is that
Так.
correct?
Yes.
And can you give us, a summary of your expertise in constitutional law?
Я вважаю, що в мене є
I believe that I have sufficient professional experience that matches the requirements to the Constitutional Court, and I believe that I have a lot of professional experience in different organs. I only worked at the state organs, so I believe that I can and I am eligible for the position at the Constitutional Court. I believe that my skills are sufficient for this.
Thank you. Closing.
Будь ласка, Василь Іванович, запитання.
Vasil Ivanovich, I have a question. Do you have relatives in Globina? No, I do not. I am from Khmelnytsky region, so I thought that you lived at your relatives in Globina. Where do you live? I rent the apartment at a hotel. It is quite a problem. I did not move my family there, and for the weekend I go to Kiev. You have a car? Yes, I do. What kind of car? Toyota. My husband's Toyota that he purchased in 2020. Well, one more question. So, you say that you have some experience and knowledge in the sphere of constitutional law. How can you demonstrate this? Do you have any publications, any scientific articles? What I meant that overall in the sphere of law I have a lot of experience, not in the sphere of constitutional law. I have quite a lot of experience at different positions. I do not have any scientific works. Understood. What is the cost of a daily rent of the apartment in Globino? You mean the cost of the room? 660 or 950 hryvnias, depending on the room. Per day. Yes, per day. For now, this is my living arrangement in Globino, but I continue looking for an apartment there. So almost half of your salary is spent on accommodation and commute. Yes. My path to the position of the judge started in 2014, and then the political events and the reform of the judiciary system led to blocking the work of the system. So I was put in reserve. In 2017, I had a chance to pass the qualification exam with a simplified procedure, and I was enlisted in the reserve. It was quite a long path due to different amendments and changes, and it was only in 2024 when I was appointed as a judge. Thank you. Any other questions to the candidate? If there are no other questions, Olena, you now have approximately 5 minutes for your final remarks. As I have already mentioned, I believe that I match the criteria of integrity that are defined for such a high position of the Constitutional Court of Ukraine. I do believe that I also match the requirements thanks to my professional knowledge and experience gained at prosecutor's office. All my activities were aimed at supporting the state and the citizens. I do not see myself in the private sphere. That is why my path towards the position of a judge was quite a lengthy one. I gained a lot of skills and a lot of knowledge, both professional and life experience, and I believe that I can be appointed to this position, in my opinion. Thank you. Thank you, Olena Leonidovna, for your response. Dear colleagues and public, at this point I declare the interview of the advisory group of experts with the candidate Fitsai closed. Thank you.